to 1 o'clock. It is Wednesday, the 28th of March. It is a rainy day in Grimes County. So y'all are the true citizens that really want to be here. We thank you for your presence. And we'll give you a moment in just a moment to make any comments that you would like to make. But before we do, would you all please rise? And we're going to ask Mac Vaughn if he would to lead us in prayer, and then we'll have the pledges to the American and the Texas flag.
Yeah, I have the podium, so I'll go ahead and make my public comment. The reason they're here, all of them are so good. They walk on water.
Make sure that's in the minutes, please.
It's on there.
Let's pray. Oh, gracious God, we just thank you for the rain that moisturizes our land and cleanses our spirits and lifts our spirits, oh God. We just ask that you guide and direct all that's said and done here at this meeting. We thank you for the leaders that are in place and the leader that's yet to come. We just ask a special blessing upon all of them. We ask a special blessing upon this meeting in Jesus' name. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Thank you so much. If you'd be seated, please. Second item on our agenda is public comments. I think Mr. Goldstein has requested to have an opportunity to speak.
Once again, I put on the firing line for an organization. This is to thank the court for their indulgence with Crime Stoppers and the money that you have given us to further our program. That money has gone against upgrading the tip line so that we are now in the 20th century. It's made it easier for the Sheriff's Department and for tips to come in. Essentially, it covers the program that we have, because we have to pay for it every year like everybody else does that is in the 20th century and in the computer business. It's provided education and the opportunity for us to attend classes to keep in compliance with the governor's mandate and the mandate that comes from the Texas State Crime Stoppers. And all in all, the members want to tell you just how much we really do appreciate it. And the other reason I'm standing here, putting myself out, is that Crime Stoppers, like the other organizations in this county, needs membership, needs people that care. This supports law enforcement. This supports your sheriff's department. The police departments. It is a necessary organization, and we would appreciate anybody that wants to become a member. Understanding that under our guidelines, anybody that is applied has to go through a check. That's it. I do appreciate it.
Mr. Goldstein, if anybody is interested in joining Crime Stoppers,
They can get
where
a-
and when would they meet?
Oh,
Or
I'm sorry. We meet third Tuesday of every month, 6 o'clock here at this courthouse.
Thank you, sir.
You want to get in touch with somebody, you can get a hold of me or Debbie Grimes.
Thank you, sir. Yes, ma'am.
Good morning, Michelle Bobo. Just wanted to let the court know that I have recently volunteered to serve on the Commissioners Court Committee for the Chamber of Commerce for Grimes County. So if there's anything that the court ever wants to relay to the chamber that they think is important, please feel free to use me as a conduit for that. As well, I plan to keep you informed, the court, if there's anything that I think you would want to know from the Chamber of Commerce. Kind of on that same page, I wanted to announce that Saturday, April 14th, from 2 to 6 p.m. in downtown Navasota, we'll be hosting our second annual Groovy Grapes Wine Walk. And so we have 8 regional wineries coming in that will be paired with downtown merchants in Navasota. We did it last year. We had about 300 attend, and so we're hoping it'll be another successful event. The city of Navasota sanctioned the event 2 nights ago at their city council meeting. So if you want to find out any more information on ticket prices, it's $20 for the commemorative wine glass to get all the wine sampling, and there's going to be food and music there. If you want to find out more, just go to the Chamber's website. 2 to 6 p.m. You can start purchasing the day of at 1:30 tickets. And it will be at the Visitor Center there on East Washington.
Since they're serving wine, do we need to bring our driver's license in case we need to be carded?
Absolutely. Especially you. Yes.
Thank you.
Thank you.
Thank
You
you.
don't have to worry, Judge.
Good morning, Judge and Commissioners,
morning.
and everyone else. April is Child Abuse Prevention Month, and next Thursday at 10 a.m. at the Law Enforcement Center here in Anderson, we will have our blue ribbon ceremony. I believe this is the 7th year we've done this, where we will be honoring the 63 confirmed cases of child abuse and neglect in Grimes County last year. We'll have a brief ceremony. Our district attorney will be there to speak, and then we'll have a short reception in the Law Enforcement Center afterwards. There's a few flyers over there if you would like to take it, but we hope to have representatives from Scotty's House, CASA of Brazos Valley, and CPS. If anybody has any questions for them or is interested in any volunteer activities with any of those. And also next Friday, April 6th is Go Blue Day, where everyone is encouraged to wear blue in solidarity against child abuse. So you don't have to pay anything, sign up, just wear blue and everyone will know what it's for. Sir?
You said the number is 63 this year. Do you have, is that number going down or is that number going up?
It's remained pretty consistent. Since we've been doing this, they've ranged from about 58 to 65. And that's only obviously confirmed cases. That doesn't include the cases that were ruled out, the cases that were the investigation was unable to be completed because the family moved or the children didn't make an outcry. I believe the numbers of unconfirmed cases was close to 200. So there were that many reports made to the statewide intake center in Austin, but 63 were confirmed as child abuse or neglect in Grimes County last calendar year.
Thank you. I guess.
You're up. I guess I'm up.
You're up.
Good morning. Thank you.
Howdy, Grimes County. I'm James Haverland. I'm the upcoming district governor for Lions Club International in Central Texas. And one of the things that I have looked at, being from College Station, is Grimes County has only 2 Lions Clubs. Well, we have a lot more school districts than that, and the schools are growing in Grimes County. What a wonderful community y'all have in Iola. What a wonderful community you have here in Anderson, Shiro. As I go around Grimes County, I'm seeing a need for service. Now, what are the Lions? Who are we? Well, first of all, we take care of kids. Kids are our #1 priority no matter what. But we've been challenged by International to do many, many things. Eyesight, Helen Keller challenged us to be Knights of the Blind back in 1925. So we buy eyeglasses for kids, we check kids' vision. We have now scanners where we can tell whether a child can see, whether they can speak or not. And so from age about 1 year old up till whatever, we can scan their eye and we can tell their parents that whether or not they can see or not, and then get them taken care of with glasses. The other things we're doing now are feeding people. So a big priority, making sure that the folks in our communities are fed, that they're taken care of. And as usual, the environment of the community, making sure that we've got great police response, that we're supporting our police and fire departments, that we're supporting our parks, that we're supporting our leaders in our counties, that we're doing the right things in our communities to make them a good place to live. And we've taken on 2 new initiatives this past year. Diabetes, because worldwide, if you're diagnosed with diabetes, it's a death sentence pretty much. And we see it as an epidemic in the United States, and certainly it's a children's epidemic. So we're working really hard for diabetes and pediatric cancer, which is a new challenge for Lions around the world. But ladies and gentlemen, we're forming a new Lions Club in Anderson, Texas. I'll be going door to door come next week. Today, I spent some time yesterday talking to some of the community leaders, and I would like to talk to all the community leaders, because the folks that we have in our Lions Club, that's who we're really after, and then the rest of the community pretty much just follows in with the leadership. So it's very important that we have the leaders, the sheriff, the mayors, the judges, the county judge, the commissioners involved in our service organization. But it goes down to anyone who actually wants to take some ownership for taking care of the people in the community. So anyway, do you have any questions for me? I'll be happy to answer them, but I'll be here next week trying to form a new club, and I foresee it quite easy in Anderson. We've got a very service-oriented organization, a very service-oriented community. Thank you very much.
Thank you.
Thank you.
Thank you very much, sir. Yes, sir.
One other thing, I'm constantly amazed at the hospitality that Grimes County extends to so many worthwhile groups, from Lions Club to Blue Ribbon, and the list goes on and on. Another one that is coming up the day before the Blue Ribbon event on April 4th at 8 or 8:30, we're having Special Olympics once again. And if you've never gone, it is a wonderful, wonderful event. They need volunteers. It's from about 8:30 till about noon, and then lunch is served at the end of the event. So I want to encourage everybody to kind of
Where's the
check
event?
out Rattler Stadium.
This is the 10th year also. The
Is it the 10th?
anniversary
Yeah.
of the special.
Yeah. That's it. Thanks.
Thank you. Are there any other public announcements? I'll take liberty, I have one. I advised Commissioners Court that I would make an announcement as to finding someone that would adequately fill Commissioner Husfeld's position as Commissioner of Precinct 4. And I went through the study of 5 applications, had 5 very competent people applied for the position. My final selection came down to who could possibly add something different, something more to the court that possibly don't currently possess. And then as I made my decision, I determined, if you don't mind, Philip, you would just stand up. I have selected Philip Choice to fill that position. Philip Cox is my choice. Sorry, Philip. My brain's working faster than my mouth. Philip Cox is my choice to fill the vacated position left by Commissioner Husfeld, which will run through 12/31 of this year. And Philip is employed. He asked to give a 2-week notice to his current employer. That's over in Waller County. Navasota. I'll get it right in a minute. Navasota. But anyway, he is going to be sworn in on Monday, April the 9th at 9 o'clock. We're going to use the courthouse steps for that. He will then take his position as Commissioner of Precinct 4, and he will be here and available for us on April the 11th. So welcome him to the court, and Mr. Cox, I will remember you're Mr. Cox, but you are my choice. So,
Thank you very much.
Mac,
What time?
Just,
9 o'clock on the swearing in. Is that it? Okay.
that's why we have it outside, so we can ride the goat.
That's correct. And that's weather permitting, and if not, we'll pull it inside and take care of business there. But anyway, I wanted to advise the court and the citizens of that decision. Are there any other public comments? And finally, are there any other public comments? Okay, moving down the agenda to consent items number 3, number 4, number 5, and number 6. Are there any questions or comments? I know we've had our papers for a while, but there still could be some comments or questions you may have.
No comments. I move to approve the court agenda items 3, 4, 5, and 6.
I second the motion.
We have a first by Commissioner Mallett and a second by Commissioner Dobianski to approve consent agenda items number 3, number 4, number 5, and number 6. There's no further discussion. All in favor say aye. Aye. All opposed? Motion carries. They are approved. With the court's permission, I've had a request from David Lilly, from Mr. Lilly. He's got another meeting to attend. I'd like to pull agenda item number 9 up, and we'll take care of that. Review and approve the preliminary plat for Reagan Estates subdivision. And you should have a big copy of that. Matt, Mr. Lilly?
Yes, Judge Commissioner, the developer for Reagan Estates has asked for the court's consideration on their preliminary plat. They approached us, it's been about, about 2 months ago, Nancy, that we first started working on this. And the location of this proposed subdivision is off of 2988 in the Whitehall area, just to the east of Highway 6. And Mr. Walker and I have reviewed this with the engineers, surveyors, and the developer, and we feel that this preliminary plat is ready for your consideration. We also have the surveyors here, and the developer, Nancy represents the developer. If you have any questions that we can't answer, they're here to help answer any questions you may have.
I had one since I didn't get the plat. Is this directly on 2988 or does it border a county road?
Directly on 2988.
And I did not mention this, the road that you see, there's a road on there. In fact, I already looked at this. The road that's shown on there, it is going to be a concrete road.
With a 200-year lifespan?
I'm sorry.
With a 200-year lifespan?
Well, if Jim Hassel builds it, yeah, that could be feasible. Mr. Hassel is planning on being the road builder, right?
He's certainly prime consideration for a final bid from him, but assuming that the cost is within reason, he's a prime candidate.
And the process, Mr. Lilly, that you're asking us to proceed with today is?
Just simply to approve the preliminary. There's no signatures involved in the approval of the preliminary plat. If there's any changes that are necessary, then we take those back to the surveyor. They make the changes to the plat before it's submitted to the final. Construction does not begin until the final plat is approved. Or at least it can go after that is approved, but construction cannot start.
Commissioner Walker, this is in your precinct?
Yes,
Sir, ma'am?
it is.
Okay.
Have any objection? Is any of this in the floodplain?
Just this top portion right here.
That's what I was thinking, if it's
The
back
lines
in
are
the.
Yeah, this creek feeds out of the flood zone, but the actual defined flood zone is just right here.
Okay. Thank you. Well, with that being said, if there aren't any other questions, I'd like to make the motion that we approve the preliminary plat for Reagan Estates subdivision.
Second. Oh,
Second motion.
There is a motion to approve agenda item number 9 by Commissioner Walker. There is a second by Commissioner Dobianski. Is any further discussion? All in favor, say aye. Aye. All opposed? Motion carries. Thank you, Mr. Lilly. Okay, we'll jump back up to item number 7, agenda item 7, Grimes County Sheriff's Office, Lieutenant Daniel Caswell. Consider and take action to approve inmate housing contract with Madison County and authorize the county judge as signatory. See attachment number 7. And it's my understanding, Lieutenant Caswell, that our county attorney has been through this and it's
This is-
effectively just what we have in
Identical
place.
Contract to Washington County, we just changed Washington to Madison, is the only changes. If John C. wants to review it for anything else.
I've already looked at it, there's just, one place got a misspelling, but it's not that big a deal. And in fact, I think I originally drafted this and it's got a spot where Madison is in there and it probably should be Grimes in paragraph 5. It says Madsion. Further agrees, should a prisoner be injured while being housed by Grimes, Grimes will within 10 hours notify Madison. It's probably Grimes' obligation, so it probably ought to be Grimes agrees. Should a prisoner be injured while being housed, Grimes will notify Madison. It probably was my drafting error originally. But the only thing I think that the court, the only significant change is the daily rate, which is $28 a day. And this is the sheriff, again, this is the sheriff's attempt to bring in some revenue. And it would be up to the court to say, we won't give this back to the sheriff. And as I said to the court previously, that there became an issue when the sheriff was endeavoring to bring in revenue to the county, that the commissioner's court said, well, that's coming in the general fund and we may or may not reallocate it to the sheriff's office. The response, as one could assume, would be, then why am I endeavoring to bring in revenue if I'm not going to get the benefit of the efforts that we're making? I don't think that's been the issue for 10 years now, and I assume that's not the issue with this court. But for you, the change to the agreement that's of any substance or consequence is the $28 per day rate, which I think is far less than the rate that Washington County.
There's a reason for that. Washington County, I don't want to put any information out there, but we're holding level 1 and 2 closed custody people accused of homicides and other special situations for them because they are not able to do it right now. So they're paying almost double. And Madison County is wanting us to send us level 6 low-risk female inmates in our general housing. So there's a big difference in what we would be holding for each county. And that's the reason the rate is a lot less, because there's a lot less liability and risk on us for what we're supposed to get from Madison versus what we've been getting from Washington.
And I would say, finally, I guess, hopefully, it'll be finally on this issue. If we have beds available or space available, it certainly makes sense that the sheriff would be endeavoring to utilize that space and bring in additional revenue. So for you, it's simply blessing the efforts of the sheriff's office and also, I think, potentially making a, I won't say commitment, suggestion to the sheriff's office that you're certainly willing to consider those dollars going back to the sheriff's office because of the work they're gonna put in on this.
Sure. That was my understanding when I talked with Lieutenant Caswell, but thank you.
Right, well, generally speaking, it's got all monies that come in have to go in the general fund, and it's up to you as to whether you allocate them back to an office, because you originally gave them money in the budget process to do whatever tasks they indicated they needed, and so you as a court get to decide, does this money go back to them or go to them? And again, I mean, you end up in a situation where elected official says, why am I agreeing to these obligations, holding myself up to a higher standard, making myself more responsible, or responsible for things that I wouldn't otherwise be responsible for, to bring in revenue that the court's not gonna allow me to participate in. I mean, obviously that makes sense to me.
Additionally, we need that revenue to do some repairs on the jail. We've got a sewage problem there that's hopefully we're gonna get fixed now with the line item transfer that we did a few minutes ago. We've got to go in and tear out some of the concrete and repair some pipe in there. So we definitely need the additional funds to help pay for that. And this will.
There's quite a few things that if once we start getting payment, we need to replace it. We haven't done it in years, so, because as you know, funds are always tight. We try to patch things and keep them rolling. There's quite a few things we need to repair and replace.
If there's no further discussion, I'll move that we approve the inmate housing contract with Madison County and authorize the county judge as signatory.
Second.
There is a motion by Commissioner Dobianski to approve agenda item number 7, and a second by Commissioner Mallett. There's no further discussion. All in favor say aye. Aye. All opposed? Motion carries. Thank you, Lieutenant. Item number 8, Grimes County Sheriff's Office. Todd Green received the Grimes County Sheriff's Office Racial Profiling Report for 2017. And all of you should have a spiral book. Chief Green?
This is our annual racial profiling report that we have to submit along to the Commissioner's Court. We've already submitted it to the state. There's a lot of verbiage and policies and stuff in here, but just meat and potatoes of it is we analyze the traffic stops we make and the searches we conduct off those, and looking at those percentage numbers, we follow pretty much percentage counts for the county. So there's nothing overwhelming that we're having to address that issue. We received no complaints again this year. And that is just a big report that we see.
Okay. I do have a question, and this is just to prove to you that I do read some of, or most of the information. But on the Grimes County page, probably a little past halfway in the document, it says that Grimes County has, covers 799 square miles. And our website says 787.46 square miles. And if you look at Wikipedia, it says 804 square miles. So I'm just concerned, are we growing, are we washing away, or whose geography numbers are probably the most relevant?
We just pull a standard probably
Okay,
out and use that. Maybe we split the middle up.
all right, well, just want to let y'all know I
And if you
do read
have
this
the
stuff.
actual accurate number, I'll be more than
Well,
happy to include that.
I've been spouting to folks that Grimes County is 804 square miles, and I just want to share truthful information with the world I speak to, so we'll just say around 800. Is that fair, Mr. Attorney?
I think you have somebody you could assign to do that. Dave Lilly comes to mind. He can go out and measure it.
He'll love that assignment. Okay, thank you, Mr. Green. So do we need to, we need to receive and approve? Well, no, we just need to receive it. All right, and you say it's already been sent to the governor's office?
Correct.
Okay. Thank you very much.
Thank you.
Tell the sheriff thank you. Number 10, Grimes County Attorney John C. Foltz consider and take action to approve an interlocal agreement between the City of Bedize and the County of Grimes regarding the regulation of complaints on new and existing on-site sewage facilities located in the city. See attachment number 10.
Judge and Commissioners, this is listed as my item, but Commissioner Mallett and I had an opportunity to talk about this. The mayor approached us about renewing the agreement that was executed last year. Ms. Hale is here if you have questions of her about how the agreement's been working. The mayor's here if you have questions of her about how the agreement's been working. It's certainly a policy issue for the court to decide whether you are going to continue to allow the county employee to provide the OSSF services to the city of Beedice. The additional question, though, that's been raised is the interlocal expires in March. It has it on its face a one-year term. The other interlocals, though, for 911, police services, road and bridge, they have a 5-year term, and my understanding is that the interlocal for those services with Beedice may be expiring in May. I think if you're going to renew this one, the question is, will you consider making this a consistent term with those others and potentially execute them all at the same time, or have them all running at the same time? As you may recall, the agreement with regard to 911 and roads and police services requires an annual review. So while it has a 5-year term, it says that the court will review this on a yearly basis, and they have essentially an automatic termination provision, maybe 30 days. I don't have it right in front of me, but it's really a policy decision of whether the court wants to continue to provide those services. I oftentimes will throw out the same concept. Yes, we have fledgling cities or municipalities. Yes, they need the county's assistance, but it is tax burden shift that you're having the people of the entire county help provide the services of a municipality. When municipalities are formed for whatever reason, and we know that at least our local history is that sewer systems are a significant issue, and municipalities often form to try to create those things. But at some point the court may have to say, and I stress may have to say to these communities that when they were formed and the folks who lived there agreed that they would be formed, that there may be a necessity that they begin to charge a tax to live in that community, to provide the services that the county has gone on the hook for this period of time. I'm not saying now is that time, but if you as the court continue to provide those, and I don't know there's been a budgetary analysis to identify what the funds are that are being spent in these communities, but if you did an analysis and you found out that there's significant dollars, there's an argument to be made from folks in one part of the county of why is it that my tax dollars are going to help this municipality in another part of the county. So I just want you to be mindful of that. I'm not saying now is the time for that, but at some point municipalities may have to begin to tax. It won't make their people happy, the people that live in those municipalities, but effectively if the county's providing those services, you're already taxing their people through county tax dollars to provide those services. So just ask you to keep your eyes open as far as that's concerned.
Thank you.
And it's a 20-day termination.
I'm sorry?
20
20.
days. Now, did I hear you say that we will be renewing some other contracts, interlocals with the city, and we're requesting at this time to renew this one they're requesting?
That's all that's on the agenda at this time, is this one that involves OSSF systems, inspections by your environmental department. As far as I know, there've been very few complaints in which the county's department has been involved to this point. But that's the only issue that you're being asked to address today. The other interlocal, it's one document that contains a provision for all three of those services that I mentioned: 911, police, and road and bridge. So it's one document that has a 5-year term, one agreement that has a 5-year term with the city of Beedice. It is expiring in May. The question is, do you want to approve this and have it have a concurrent term, if you will, with that other interlocal? At some point, and whether it's May or not, we could consolidate the agreements. This issue just came up after those other issues came up.
It would seem smart to have them all at the same time, so we don't have to keep watching the calendar all year long, even though we already do. But I mean, if Beedice came up all in May and we approved them all at the same time or disapproved them, at least collectively we have it all together.
unless you saw these, services as being distinct and different, and we don't wanna provide this, and we do wanna provide that, then I would agree with you that having them on a 5 year is not a bad idea, as long as they continue to be subject to annual review. My fear is always, you're well aware of the turnover that occurs on the court. And if you put one person in charge, or a couple of folks in charge of remembering to put this on the calendar, or whatever it may be, if you have turnover in your office, whether it be the staff, or whether it be you, or you have turnover with the commissioner that was assigned the task, it gets lost and it falls through the cracks. And so my request would be that it continue to be addressed. And the reason the court originally put it up for an annual review, I think, and I may be mistaken and the mayor may not want to hear me say this, but it was because the court wanted to continue to look every year and say,
Sure.
what efforts is the municipality making to get on its own feet? And you may have to, now there's turnover, so I think they bought some more time with the new court, but you ought to be inspecting, and I know you will be in your budget process, you ought to be considering what dollars are being allocated in those communities through these interlocals. And you may not be able to find good evidence because the amount of manpower that Road and Bridge spends there, you may not have a certain number of hours written down. The amount of police power, police services, you may not have written down. 911, same thing. If you want to though, or if it's of significant concern to you, you have people that are subordinate to the court from whom you could ask for that information.
Ms. Hale, how often do you have to check the facility?
I probably have about 2 cases out there, but my issue is more with the way it's written, because they can't construct septic systems in city limits. They have to connect to city sewer, so that's more along the lines of the issue I find with the interlocal agreement, is it's stating new and existing construction of on-site sewage facilities.
Which item? New and existing, about the 4th paragraph?
Yeah, the on-site sewage facilities, there are no on-site sewage facilities in
Right.
Dallas. They
And they're
must
not allowed
connect
to
that.
put new ones in, so that's kind of the issue I have.
Yeah.
Is I don't feel like the DR has the correct jurisdiction to enforce city sewer connection. I can issue the nuisance citation, or letter, and hope that the sheriff's department will issue a nuisance citation. But I can't force anybody to connect to the city sewer, and they can't put in a new septic system in city limits. So that's where I find an issue.
So do you have any jurisdiction over any health concerns, like if they're dumping raw
Right,
sewage?
if it's
You
dumping,
do?
then I can issue a nuisance letter, and they'll have 30 days, and then I can have the sheriff's department issue a citation. But then that still leaves us with the issue that, I mean, I don't have the authority to force them to connect to city
Sure,
sewer.
sure.
So that's my issue that I've come across.
So
And
you're,
I've sent out letters, and they either come back, or we meet with the tenant or the person living there, but in the end of it, if I can't get them to connect and the city can't get them to connect, then we continue this same process.
But if there continue to be a health problem, then there's still jurisdiction the sheriff's department can take.
Correct.
but right now your problem is with the wording right there.
Right, because they can't put in a septic system in city limits, and I don't believe that there are any within the city limits.
So we could reword this to, health concerns or sanitary, just some different language
Right.
would be okay?
With that being said about running concurrently with the other interlocals, but the annual inspection, is there annual inspection that you do?
No.
Annual review?
No, it's just
No,
strictly,
just
yeah, strictly enforcement
It's
issues of any
strictly
sanitary.
enforcement.
Right, that, and she can certainly tell us better, but I'm aware of one circumstance where the city was concerned that there was running of, material or whatever on the ground, for which they don't have an enforcement mechanism to go out and take care of it, and so they wanted the assistance of the county. She may have had more than that one, but.
Yeah, we had another one.
Okay.
And I had sent out a letter, it came back, and had no contact with the person, so I had a call from the mayor's secretary that it was currently running, and I said, well, if it's immediately running, call the sheriff's department and get somebody out there to open a report on it for their side, so it makes it easier when the citation needs to get issued, they already have a report on what's been going on. Dispatch had called me to say they were sending someone out, but I had
So I think we have 2 issues in a year, and so I don't know if that was the number you were looking for, but, okay.
It was, but I was going somewhere with it. I was gonna say, why not, redraft this to do 5 years with the annual review wording?
Sure, and the other one expires in May. We may not have one in place because this expires, I think, March the 24th or a couple of days ago. We may not have one in effect between now and the time that it gets revised and executed. But if we've had 2 complaints over a year, it may be that there's not gonna be an issue within the next, whatever it is, 10 days or so. I was unaware, Marissa, or Ms. Hale and I had a conversation about this. The designation of DR and whether that person can serve in the city requires, according to TCEQ, requires the city to take certain action. And I think that's where she's felt like that she doesn't have the authority from her designation through TCEQ to provide the type of services we're talking about. We haven't talked about revising the agreement before, and so we'll need to talk about that. If one or more of the members of the court wants to participate in that discussion, it'll be fine. She and I can probably hammer that out, and I can have something to present to you either at the next meeting, or if you want to move it closer to the expiration of the other interlocals, or if you want to move the other interlocals up,
Yeah.
and we can do that in April.
I would say we move them up so that, you're not left without, this enforcement ability, because we don't wanna wait to May, you know,
Sure.
and be like we are now. This is already expired, right? You said the 24th, so,
I think that's right. So if you want to
Yeah.
put it on the next agenda and give me an opportunity to revise the language, and then, in fact, I mean, there's really no reason that we couldn't consolidate this with the other services and make it all one agreement.
Mary, did you have a
That was
comment?
suggestion.
First of all, thank you so much to the county for having all of these interlocals. It's just essential for us as a city. And Marissa's been wonderful to work with, and there have been only 2 so far. Let's hope there's no more than 2 a year. But also to remind the court that there is a fee that the city is paying. I don't know that we've been billed, but we should, but there is a fee involved. Anytime that she takes action, the city has agreed to pay a fee, which I think is very appropriate.
Is that that $200 charge?
Yes.
And I misspoke, it's the 28th, so that interlocal is up to date. Or maybe yesterday. So we can put it on the next regular agenda. I will revise the agreement, probably consolidate all of them. And I think this is the only city for whom the county has extended this commitment, and so we don't necessarily need to revise the other interlocals. But just in my mind, I can't think of a reason not to consolidate them. So I'll have that to present, or I'll have that discussion with Ms. Hale, and then hopefully have that document to present to you at the next meeting, the next regular meeting.
And that was just my suggestion, I mean,
I think that's a good suggestion. Pull them up and get it all
Put them
done.
all in April.
So we'll-
Do you wanna give a 2-week extension on this one to cover it while, during the time that he's redoing the paperwork and so forth?
John, is that appropriate?
Oh, it's entirely up to you. You could say we're gonna grant, I mean, it's an interlocal agreement, it's an agreement between the 2 communities, or 2 governmental entities, has to be approved by the other body. What you're saying is, we're not gonna approve the agreement as it's written, we're gonna make it a 2-week term, or whatever it is, to the next regular meeting. But to be a valid agreement, effectively, it would have to be approved by the city of Vidas. And they haven't heard that term until just now.
We approved last month, we approved the existing for an extension. But obviously.
But not for 30
there's-
weeks, though, right?
Right. Contingent upon the court.
Unless you and Mary were hanging out talking.
let me understand again, you say you approved the existing for an extension till,
For a year, and, or whatever the court decided. We had talked about it last month, and I don't know if that now would be legal since the wording would be changed, but we did, the council approved it contingent upon the commissioner's court approving it.
You can certainly make that your motion, and when we ask we ask ourselves the question whether it's a legitimate agreement, we're considering whether someone's gonna file a breach of contract later. I mean, that's the reason you ask that question. If you say I'm going to agree to that, and what you're agreeing to is to make Ms. Hale available for, and I'll just say it, the mayor, when the mayor has when the mayor brings an issue that the court, that her counsel is concerned about, to Ms. Hale. And is something gonna happen the next 3 weeks? I don't know. Is it gonna be urgent where Ms. Hale's gotta drop everything and go out there and check tomorrow? I don't know. I think we're more concerned about this overlap than is necessary, but it's fine. I don't think it's harmful to say we'll grant it for 3 weeks or 4 weeks and we'll revisit it when we come back with the new agreement. It's fine. And then hopefully the city will say it's fine by them, but do they have to? What matters is when the mayor calls Ms. Hale, what does Ms. Hale know that she can do, or that she should do?
Somebody want to venture a motion?
I don't wanna venture the motion. You wanna venture?
I can try. I move to extend the interlocal agreement, for the, let's see,
Between-
sanitary health matters, I guess we'll put that, for, with the city of Beat Eyes,
Till the next regular
till the
meeting.
next regular meeting.
I second it.
All right. We have a motion on agenda item number 10 by Commissioner Mallett, a first by Commissioner Mallett. We have a second by Commissioner Walker. All in further discussion? All in favor say aye.
Aye.
Aye. All opposed? Okay. So, Ms. Wagner, if you'll make sure you hustle our county attorney for the revised language, and we'll put that on the April 11th agenda, okay? Thank you, John C.
Yes.
Number 11, Road and Bridge, Engineer Harry Walker. Consideration and possible approval for a communication line permit for CenturyLink on County Road 420. Authorize the county judge's signatory, see attachment 11. Mr. Walker?
Good morning, Judge, Commissioners. CenturyLink has applied for a permit to install a 96-pair fiber optic cable on County Road 420 in the Minnesota area, which start at Highway 6 and run south. Doesn't quite go to the opposite end of 420, but just past the intersection with 420A. Again, they've met our permitting requirements. I'd recommend approval of this matter.
So it's running, along 420, but is it boring under or?
They will bore the road crossings and the driveways and open cut the trenches in between.
Okay. Does anybody have any questions about it? Then I would like to make the motion that we approve for a communications line permit for CenturyLink on County Road 420 and authorize the county judge's signatory.
I second the motion.
There's a motion on agenda item number 11 by Commissioner Walker. There's a second by Commissioner Dobianski. If there is no further discussion, all in favor say aye.
Aye.
All opposed? Motion carries. Agenda item number 12, consideration and possible approval of revision to the subdivision regulation relating to the 50% development requirement for accepting roads into the county maintenance system, attachment number 12. Mr. Walker?
This is a matter that came up a couple months ago in the course of a meeting with Ms. Perry and one of the development groups that's working in the county. In, I believe, 2014, the county added a requirement to the subdivision regulations that before we would accept new roads into the county maintenance system, not only had those roads had to be under maintenance by the developer for a year, but the development also had to achieve 50% build out
of the development. And I believe this was the first time this particular development group had run into this new provision, and were somewhat concerned about it, primarily because the bonding requirements are essentially open-ended. There's no way to know how long a new subdivision is going to take to reach 50% build out. So it's a legitimate concern. I understand their concerns. I suggested at the time that they contact the commissioners and approach this subject with them. They did contact Commissioner Husfeld. He came back and got with Dave Lilly and I and suggested as a solution to this situation that we modify the subdivision regulations to delete the 50% build out requirement in the case where developers are putting in concrete streets, but not in the case for asphalt. And that's due to just the higher level of maintenance that's required on asphalt streets typically, and the greater likelihood that they will be damaged during the period when the subdivision's under active housing construction. So,
But there is also a financial consideration in here. State, you said state status specifically permits an owner to deposit cash, a letter of credit issued by a federally insured financial institution, or other acceptable financial guarantee. That's the other.
That's the other part of this. The question came up as we started working on this, if other types of security besides bonds would be acceptable. One of a different developer in the county suggested, what if I put up a CD in the county's name? And talked to the county attorney, and he found some language in the state statutes that allow other types of financial guarantees that are acceptable, including letters of credit. So that would also be a recommended revision to the subdivision ordinances that would give developers a little bit more latitude on how to deal with this particular issue, particularly in the case if you decide either not to change the 50% build out requirement, or for developers who are putting in asphalt roads would have some more flexibility in how they address the financial security.
I like how you did the pros and cons. Kind of laid it out a little bit better for us.
And if I could address it for the judge, if for nobody else, 'cause I know it's, I prefer you not tell me you're green, but I can tell you you're green. So,
Yes,
these regs were drafted soon after I took office, so 10, 12 years ago, and we have refined them on numerous occasions. And usually we've done it at the urging of the Road and Bridge Department. So it's usually been the engineer. I don't recall that we made any changes under an administrator, though we may have. I know that I worked with Bobby Liz to try to get these the way the court wanted them, or the way that he thought they needed to be. We worked certainly with Bob Cochran. This provision in question, I think, was added when Bob Cochran was here. And I wanted to say to you, the court, but specifically you, Judge, you have a department whose main job is to worry about roads and bridges. And if you have sub-regs that were primarily, at least originally, drafted to address roads and drainage, then that would be the department, I think. If you trust your engineer, you trust your professional, that would be the department that you would expect to bring you particular or potential refining opportunities, suggestions that you modify your language where we see things are not working the way that the court had hoped, or where the court sees that things could be worked a little bit better. So I know this is, just throwing it on your plate and asking you to see all of the changes potentially of how we've gotten to the point that we are. I'm trying to liberate you to say, I have a professional for this, and at least one of the commissioners took a long, hard look at this. You may from time to time make changes that you find aren't workable, or that are onerous to developers, or that are too light on developers than what you would prefer there be for the benefit of the taxpayer, for the folks that you represent. Sometimes, though, you have to make those changes on the best advice that you have. And in this case, it may be from your expert to say, I've looked at all sides of this thing. It seems to me that it makes sense that we make this modification. If it turns out later it's a bad idea, we can make the change and come back to where we started.
And I also like the fact in here that it talks about how it's going to allow, I would say, a competitive advantage for the developers in our areas that are wanting to come into our areas. Our current existing regulations, it says, puts them at a disadvantage according to other surrounding counties who have that do not have the same criteria. So other counties around us, they don't per se have the same criteria we have. So it makes it hard for the developers.
I have not, surveyed the other counties around what their requirements are, but I have been told by others that are knowledgeable that this is an unusual requirement, and I'll
Just pertaining to concrete roads. So.
Yes, yes. Well, that the requirement for the 50% build out is uncommon, and it. I can see the potential for creating issues, both from a competitive standpoint as well as from how do the developers actually go about providing the bonding. One of the issues being that with the smaller developers that are more active in the county, frequently the bonds are provided through their contractor. And the issue there is the contractor doesn't want to have his bonding capacity tied up for an extended period of time. Because if he doesn't have bonding capacity, he can't go out and get other projects. So that's where part of the rub comes in. But the competitive situation, I'll trust the real estate professionals to tell me that that's a situation that would exist, and logically it would make a difference, yes.
And they would be following, in order to build concrete roads here, we have criteria in place.
Yes, and that was one of Commissioner Husfeld's key points too, was to make sure that we had a robust inspection program, whether it's concrete or asphalt streets, to ensure we didn't have some of the issues that have contributed to the need for this requirement in the past.
And Judge, if I could make, and I hate to belabor it, but I think it's worth discussing. If you haven't gotten complaints about roads yet, you will. It's a significant issue. It's probably
I'm
top
no
of the
longer
list.
green in that area.
Probably very top of the list. And sometimes the county finds itself in a difficult position to try to assist in a subdivision that was created under cover of darkness, or was created where the roads weren't brought to county specifications, or where the roads became private easements only, given to each of the landowners within the subdivision. In those cases, it's very difficult. We have yet to master how to solve that problem for folks that I think everybody on the court has always had a heart for folks that struggle with their roads. The question is how to spend taxpayer dollars, and a significant amount of taxpayer dollars, to fix these roads that were created through no fault of the county, to be quite honest with you. But the most significant thing that you can do is be preventative by requiring security on the front end for developments that come in the future, or that are coming in now. And that's what we're talking about here, is the financial guarantee. The code specifically says other acceptable financial guarantee, which to me, acceptable means acceptable to you, because this is your policy. The 50% rule came up because Mr. Cochran recognized that some subdivisions would have build out of the roads but no build out of the homes, and 1 year could elapse and there be no real traffic on a road and it looks like it's fine, the county accepts it into the network, and then when the houses begin to get constructed,
Right.
the road falls apart in front of your eyes, guess whose road it is to now repair? The
Ours.
county's. So that's the issue, and that's where that arose, and I think that's where Commissioner Husfield as well as Mr. Walker came up with the idea of differentiating between concrete and asphalt. But I will tell you that this court, and not all the same members, have certainly addressed the issue of what happened in various subdivisions that are even being built out now, where roads were deficient, roads fell apart, whether it was the plasticity or whatever the engineering problems were with the road, it fell apart. And if the court is not conscientious about requiring the financial guarantee, understanding the review period, making sure we do the inspection, making sure that you have the right person at the top of your road and bridge department to do the job, you're gonna find yourself leaving, leaving yourself further complaints from people about roads, but certainly leaving future courts to face the same types of complaints that you're facing now that courts in the past may have left for you. So I just want to give, if you hadn't explored that big picture, there was a reason for the 50% rule.
Right.
And Mr. Cochran came and said, I think this is a way we can solve that problem. If Mr. Walker is saying his analysis of it indicates that it may be time to do away with that, at least for concrete, then I certainly trust his opinion. But you as the court may have to answer for the status of the roads or the state of the roads.
Mr. Walker, do you see the same scenario happening when you accept the roads in and then there's construction on and the heavy?
What we have seen, and during one of our meetings with Ms. Perry, we went through a listing of some of the recent subdivisions in the county, and many of them, it's taken 7, 8, 10 years to get to that 50% build out. Now, the concern from the road damage standpoint, the heavy construction loads during the home building period, the concrete trucks, the lumber trucks and things, do much more damage than just the daily wear and tear of people driving back and forth to work. So I understand where the concern came from originally. I understand the implications for the development community if they have trouble getting bonding. We had at least one contractor that just flat said, I won't build roads in Grimes County if this is gonna be the criteria. I won't have my bonding capacity tied up for that long. So that's an issue. We want to have competition in the construction community for the benefit of the developers to keep their costs down. But we don't want to unduly take that burden on the county and have no protections.
Right.
This is an attempt to balance those concerns, recognizing that concrete streets are just much more forgiving. Now, it does create up a competitive difference between concrete and asphalt. That's somewhat self-serving in that we, as the county, having to maintain these roads, are better off in the long run if all roads were concrete, because there'd be much less maintenance, and I wouldn't have as much to do. What I might suggest, with your permission, we have representatives here from the development community that might want to speak to this, if you don't mind.
I'm happy to answer questions if y'all have questions for me.
Well, I also think that there was in the past, there was a lack of oversight of some of the roads being built, so there may have been some shortcuts taken. I know in the last couple of sections in King Oaks, there was a lot better oversight and stayed on top of it a lot better, and I think we got some better.
And I think you ended up doing a back entrance or something for the construction
Keep some
trucks
of
to
the trucks
come
off
into.
of the other
But
districts.
much like the map we looked at earlier, if that's the only way in, then, my concern is, I don't know how much more it is to repair a concrete road than it is an asphalt road, but yeah, certainly concrete roads look like they hold up a little bit better.
They hold up better, but it is more expensive, more difficult to keep up with. So that's part of the trade-off.
That's the trade-off, okay. Are you seeing a lot of development with concrete roads, Ms.?
No, we're not.
You're
Now,
not?
we are encouraging concrete when it's competitively, if it's close to the same cost as asphalt, the average developer is gonna go ahead and put in concrete. The concrete roads that we have in existence in Grimes County right now, primarily, most of them were built by Jim Hassel. If you go into Heritage Meadow, that subdivision was built probably 30 years ago. I don't think there's been a single repair to that road. I don't think there's any needed. I think it's perfectly fine. You look at the other concrete streets that were built in Holland Ridge, they're perfect. There's no problems at all. River Haven, those streets are good. There's no issue. River Haven is not built out. There's some underlying problems there. I don't know if it's going to be built out or when. There's some personal problems inside the development of that. Whenever you go and you look at Vista Hills, it took about 8 or 10 years for it to build out to a 50% capacity. I think Glenn Fuquay built that road, and it lasted pretty well. It lasted for several years. They have had to go in and rework it.
It's concrete or asphalt?
It's asphalt. That one's asphalt. We know that asphalt breaks down on the edges particularly, and if it's not built right to start with, stabilized right underneath, then it's not going to hold up. I think that the burden really lies with the county supervising the construction of an asphalt road when it's going in to make sure that that builder or developer contractor is actually building the road to the county specs. Now, it's my understanding that the county has the right at the end of the year to inspect the road and to accept it or deny it. You're not automatically obligated to accept the road just because it was bonded for 1 year. If it's not up to snuff at the end of the year, you can say, no, we're not taking this road because it wasn't built right. Now, it's a double-edged sword because the county, I guess, has an inspector, I don't know if it's Mr. Lilly or if it's Mr. Walker, that needs to watch that construction while it's going in. Now, right now, we have 3 subdivisions that are planned, not Holland Ridge, Reagan Estates, Horseshoe Acres, and Pecan Valley. Now, Mr. Trione, who is a substantial landowner in the area, was planning Pecan Valley. He owned a total of 1,400 acres out there. He's got about 1,200 left. And he ultimately planned on putting a street from 446 all the way through to Highway 90 and looping around and having a couple of loops in there. This process that we're going through right now has caused him to come into my office yesterday and say, forget it. I'm not building it. I'm not dealing with it. He wanted to put an asphalt road in. He thought the asphalt road was country. It represented in his mind it created the environment that he's seen for Pecan Valley growing into. Estate tracts anywhere from 11 to 50 acre parcels. And even though we all think, and I personally think, that we're way ahead and better off with concrete, I hate to make it a mandatory, or I hate to give and I love the concrete man, he's a personal friend of mine, and I'm 100% behind him, but I hate to give him the advantage over Glenn Fuquay or any other developer, any other contractor in the area to say that we can only have concrete streets. Now, if concrete streets were 10 or 20% more than asphalt, then we all would all be concrete. But we also want to stay competitive with Washington, Waller, Madison, Montgomery, Brazos, the counties around us that are growing and developing. Our requirements should not be any more stringent than those counties. Washington County has been ahead of us for a while. Now we're catching up. But I don't want to fall behind because I have a developer that wants to develop a nice subdivision, and he says, I can do it over in Washington County 20% less than I can do it in Grimes County. or where you have a road contractor that tells me, I'll never build another road in Grimes County as long as I live.
Well, let
I'm
me
not putting
ask
up-
you this,
I'm-
Ms.
I've got
Nancy.
those contractors telling me they won't work here.
There was an option to do concrete or asphalt, right?
Yes.
Okay, so he was wanting to do asphalt,
Mr.
But-
Town wanted specifically to do asphalt.
okay,
And he is the one that said that he could put up a CD, whatever, and he can. He's qualified, he's capable. But it all boils down to, if it costs you so much to do a development that you're not gonna make a profit at the end of the day, why would you do it?
I'm trying to find out what the problem was.
The problem was that he found the difficulty of going through the platting and the construction process to not be economically feasible enough for him to complete his plan. So he just said he just sell the land in 2 or 3 big chunks and forget it, and not do a development. Now, I personally am involved pretty in depth with all of these developers, and I understand, if you can sell a tract of land for $10,000 or $12,000 an acre undeveloped in a 20 or 30, in a 100, 200 or 300 acre tract, and you're only gonna get, $5,000 or $6,000 an acre more after you build streets and do all the drainage and do all the electrical and everything else, then you're breaking even at best. You're not making a profit, why are you gonna do it?
So
Now-
that was the issue,
Yeah,
basically. It
now-
wasn't that we were being so stringent on our end to where
Well-
he didn't have an option to whether to go
He felt like
concrete or
that, he felt
asphalt.
like he's going to have to do concrete, and I think he just said he ain't going to. Now,
And that was because he didn't want to do this financial part, or letter of credit, or the acceptable financial
He
guarantee.
did not give me a specific, exact point to say, this is why I'm not gonna do it. He just came into my office, said, I'm not gonna make any money, it's gonna cost too much to do this, and I'll just sell it at a big tract.
So, in other words, what I'm trying to get to, Mr. Walker, is, are we running into the same issues with the, build out on the asphalt roads too, compared to the concrete road? Are we tying them up too long on asphalt?
Well, that's a concern. The asphalt roads are just much more susceptible to the damage that occurs during home building. And I think there's a much stronger justification for having more stringent requirements for asphalt roads. And, certainly this is not the only way to address this issue. There are other options that could be explored, just extending the bonding period, but not making it open-ended, things like that. So definitely, if I had to choose, have a less stringent process, it would be for concrete streets and for asphalt. They have to be built better, and even if they're built properly, they're much more susceptible to damage during home building. And we see that all over. One thing you might want to consider, this is kind of turned into a conversation, I'm talking about setting up a workshop. Bring some of the
Sounds
other
like it.
developers in, and have a thorough discussion, what the pros and cons are for
Well, that does sound like a good idea, but what we're dealing with today, I think it makes good sense, and I trust his judgment as a county engineer. I mean, like he said, we put
He's our subject matter expert.
Yes, thank you. So, did any of you all have any?
The comment that I have on it is, when I took office, we were working with Ground Range out here on some roads that they had developed.
we went out and took core samples on the road, made them put more asphalt on it because there was some fall in the road that they built. And after an extended period, we took the bond off of that road, even though they're gonna, those roads will be taken care of by homeowners association and some, not taxpayers, we still required them to do that. And they built a number of homes on that road, and the last time I've been in there, it's not been to work. So I think the inspection process will help a lot with that. As Chad talked about the problem we had at King Oaks out here. We gotta be more vigilant on that and make sure that they're done right at the start.
Well, we
But
know
the
King
develop-
Oaks is a deep septic too. Yeah, 'cause
The builder of those roads out in Crown Ranch has done an excellent job out there. Mike Eubanks, he does a good job on it.
Judge, we can't hear
Yeah.
conversation over here.
Okay. David, you'll have to speak up, Commissioner.
Okay.
Turn the rank down.
Yeah.
When I took office, back in 2015, we went out and inspected roads out at Crown Ranch and, did some core samples and made them redo part of that road out there that we were taking into the county. And, as a result of that, when they started building in there was no damage to that road, as the last time, and there's several houses built back in there. So my comment is, we need to be more vigilant in inspecting those roads as they're being built, and make sure that the contractors are building them to the standards that we have.
Mr. Engineer, you got any, you like this suggestion?
Yes, and maybe we can, like I said, meet in a workshop and kind of further evaluate, whether it's a fixed timeframe, for a maintenance bond, or instead of, it's 7 to 8 year out.
Can I make a comment? We have a subdivision that the developer recently became ill, so we're a little bit behind on finalizing that plat. It's ready to finalize, it should be, the final plat should be presented next commissioners meeting. That road is supposed to, the construction of that road is supposed to happen immediately, like now. Mr. Hassel has the contract to build that one. If we don't have a ruling on allowing him to build a concrete road in there with a 1-year bond, he's not gonna build the road. He has absolutely refused to build that road if he has to bond it for more than 1 year. And if we're gonna do a workshop, it's gonna take 2 or 3 months to get the decisions made, then all of the development that is happening right now in Grimes County, these new subdivisions is gonna stop.
Judge, for
I
the
was
benefit of the
talking
spirit, I
about-
think they were about to make a motion to approve.
Yeah,
But,
yes, sir.
but I would say on the issue of the workshop, just be sure if you do hold a workshop, I recognize that you're probably gonna take action now, and then hold a workshop to have further discussion about maybe
Asphalt.
eliminating, asphalt as well from the requirement. If you hold, and we've done this at least one time before, be sure that you're considerate of real estate agents, surveyors, and title companies, as well as developers. All of those folks probably need to have input, and they may choose not to show up, and that's happened before.
Sure.
But all of those industries are affected. There are other industries, and if there were a lender that was involved, that was offering a letter of credit or whatever, those folks might be interested as well. Just want to be sure that I'm throwing out, those are the various folks that need to have a seat at the table, and whether they choose to sit in it, that'll be up to them.
And I think, Ms. Perry, we were talking about having a workshop for asphalt,
asphalt.
looking at that too. If there aren't any other concerns or questions, I would like to make the motion that we approve the revisions to the subdivision regulations regulating to the 50% development requirement for accepting roads into the county maintenance system.
Would that be as presented or as just to remove the,
As presented.
I'll second it.
There is a motion before the court on agenda item number 12 by Commissioner Walker. There's a second by Commissioner Mallett. All in favor, say aye.
Aye.
All opposed? Motion carries.
And Judge and Commissioners, what'll happen is, I think Mr. Walker gave you the summary. I think Mr. Husfield and Mr. Walker tinkered with the changes in the regs themselves. We usually, when we do a change, I think we noted at the bottom the date that the change was made. We'll work with Mr. Walker to be sure that our regs are changed to be consistent with the change that you made today.
Before we move past this item completely, how long do you think it would take to notify maybe some of the entities that Mr. Foltz has recommended for us to put together a workshop to have a thorough discussion of what's going to be best for the county, but also best for those that are interested in putting in developments in the county?
Oh, I think we can come up with a list of potential attendees and get it out in a week or so's time. And
About a month.
maybe set it up for let's say a month from now.
Sometime during April?
Sometime during April, we'll
Alright.
try for 2 weeks.
Because our community would have to know, and they would have to adjust their calendar.
Sure, right, give them some time to do that. Okay. Well, my office would be glad to work with you on, if you can help put that list together, and Ms. Perry, if you even have some suggestions as to, who you think would be, from the developer standpoint, help us gather that information, and then we can send out a letter from the office and invite them to that workshop. We'll get it scheduled. Thank you. Okay, let's move on then to number 13, consideration and possible approval of order rescinding right-of-way deed of dedication from Robert Ostrakill to Grimes County. See attachment 13. Mr. Walker.
Fortunately, Mr. Usherson is not here to listen to us butcher his name today.
Say it again.
I said Ostrakill.
Okay.
I'm not sure that's how he pronounces it. but
Okay.
It's,
We'll just call him Robert for today, okay?
this is an interesting situation. Has to do with County Road 162. In 2011, the county started the process for having the bridge on County Road 162 at the Navasota River Relief Channel replaced through the TxDOT Bridge Program. One of the things they wanted to do in that project was to realign the bridge so they'd have a better angle for the crossing. As it stood at the time, there's almost a 90-degree turn coming into the approach to the bridge. So, the county at the time approached Mr. Ostrakill, who's happened to be the property owner on both sides of the bridge at the time, and asked if he would be willing to convey it right away to allow them to realign the bridge, which he agreed to do. That conveyance was executed, the deed was signed over to the county in 2011. After that, as some time passed, TxDOT got into the design phase of the project, they realized that new alignment was going to have significant wetlands impacts. And you can do that, but there were significant costs associated with that. That issue was brought to the commissioners at the time, and a decision was made ultimately to go back to the existing alignment of the road and not spend money to deal with the wetlands issues.
It was in the range of about $400,000 more or so.
Yeah, it was very hefty. And I've really condensed this because this took place over a period of years. But in the meantime, the right-of-way had been conveyed. It was in the county's name. When the decision was made not to utilize that because of the cost issues associated with the wetlands, Mr. Ostrakill was never advised of that. Last year, the bridge was actually completed on the original alignment. It still has the bad curve coming into the bridge. And he hadn't been out there since before the bridge construction started because of access issues. And he called me one day and said, y'all built the bridge in the wrong place. we looked into it, we researched it and found out that in fact the bridge was built on the original road right of way, and we had not utilized the new right of way that we had acquired from him. And this was a donation. And he said, you know, obviously you're not gonna move the bridge at this point, can I at least get my right of way back? That seems reasonable. So what this order intends to do is to rescind the action that was taken by the Commissioners Court back in 2011 that accepted the donation of the right of way. Basically, we're taking a mulligan and saying we never did that, we're undoing what we did. The right of way would go back to Mr. Ostrasil. The county still has the right of way that has been used for the road for many years. The bridge is complete and it's still got bad turns coming in the bridge. But not the greatest situation in the world, but I think we owe it to the property owner who was willing to cooperate with us to at least give him the property back. And he's asked that we replace the culvert for his driveway and a gate that had been there at the time. They'd actually gone out and cleared the new right of way before all these issues came up, so he lost some of his improvements as well. So I told him we'd bring this forward with a recommendation that you take this action and basically avoid the action that was taken by Commissioner's Court back 7 years ago.
And it's within our legal authority to replace the culvert, the gate, and those kinds of things?
Yes.
Okay.
I move to approve the order rescinding the right of way deed of dedication from Robert Ostrasil to Grimes County.
I second the motion.
There's been a motion made by Commissioner Mallett on agenda item 13. There's been a second by Commissioner Dobianski. All in favor, say aye. Aye. All opposed, motion carries.
Judge and Commissioners, to be sure that the county clerk's office can record it in the real property records, I added a notary block to it. There's only one notary spot for all 4 of you. So we'll need one notary to have you all swear at the same time, like immediately after the meeting or something to that effect.
Okay, Cherie's a notary, so.
That'll be fine.
Okay.
Just want to be sure that, I didn't break it down where each person could go to a separate notary, so we need to catch everybody while we can.
Okay, thank you. Road and Bridge report, Mr. Walker?
Thank you. Crews have been busy. The weather up until today has been conducive to actually getting some work done for a while. Some of the highlights, we have continued to work on the County Road 141 and County Road 404 bridge replacements. Hopefully our contractor will be ready next week to deliver the box culverts so we can install those at those locations. But we have removed the existing structures and prepared the sites as best we can so that when they bring the boxes out, we'll be good and set and we'll go ahead and put those roads back together and reopen them. So,
You talked about the boxes that are on 408 there. That's gonna
yes, sir. These are the boxes that were put in on 408 under that TxDOT project as a temporary bypass. That project is rapidly coming to completion. Hopefully they'll have their last concrete pour this week. Hopefully they got it before today.
They did. I was there yesterday.
Okay.
On 408, and they did.
The schedule may slip again.
Yeah.
But they offered these boxes to us. TxDOT won't let them reuse them.
Right.
It was gonna cost the contractor more to haul them out of there with no guarantee that he was gonna have anything to do with them. So he said, I'll give y'all the boxes if y'all pay for the crane to load them and the hauling to move them to wherever you want. So that sounds like a pretty good deal. So we're trying to take advantage of that. The schedule has slipped because of the winter weather slowed him down. He can't remove the bypass until he can put traffic on the new bridge, so it's been kind of a domino effect, but I think we're in sight of getting that done. We did find out last week, we had excavated the location for the 141 bridge, which will be somewhat deeper than the existing creek. We found out last week with the rain that there are quite a few fish in that creek. Not only catfish, but bass and the crew was
Are you
threatening to have a fish
advertising?
fry out there. It's kind of interesting. We also, of note, we had contract tree removal service in working the last several weeks. We have completed that work as of this week. They did a good job for us, took out a lot of trees. Hopefully, as we get into the spring storms, we won't get as many calls in the middle of the night to come out and move down trees. Our side ditcher's been busy. We're up to 107 miles. The ditch is cleared so far this year. That's going really well. Since we put him in the electronic age and he's not having to wheel off his distances, we're able to get a lot more accomplished with that machine. Any questions?
Did you speak with the contractor that's doing those two bridges recently?
Oh, I talked to him the end of last week.
Okay. Cause I talked to Chad Boney yesterday, because I got a call from Moody's on 190 Bridge. They haven't been back.
Speak up so they can hear it.
They have not been back on that site, and I went by the one on 408 yesterday, and they weren't working over there.
Yeah, I know they are trying to complete another project they have with
Yeah.
TxDOT, and so they've been pulling their crews back and forth. They have assured me they will take care of some of the issues that Mr. Moody raised.
Yeah, and they did.
190 Bridge.
They did.
So, and again, both of those contracts are due to be finished in the next few weeks completely, sites restored and everything, so. But yeah, I know he's been juggling crews back and forth between some other projects that's drawn this process out.
Okay.
Thank you, sir.
Thank you.
Agenda item number 14, consider and take action to adopt an order before March 31st, 2018, authorize the sale of fireworks for the San Jacinto Day fireworks period of April 16, 2018 through midnight on April 21st, 2018, and authorize the county judge's signatory. See attachment 14.
Have we had San Jacinto Day before?
I don't know if this issue was approved, less than 5 years ago. I don't recall if this has been on the agenda before, maybe one time.
I think San Jacinto was.
Oh, okay. My staff is telling me it was the last session that it got approved, so this may be the first time or the second time. Yeah, so I don't recall. You mean you don't celebrate San Jacinto Day with fireworks every year?
I bet. This is new to me.
Well, you're no Texan.
Well, I am.
And the slip that you have attached, just because I like to say sticks and fins. The
Yes.
slip you have attached says, this is the one where you can approve the sale, and if you approve the sale, you could say, but we prohibit sticks and fins.
I don't think we need to
He's
do
always
that.
got to.
Yeah, I think it's well enough.
He's always got to talk sticks and pins. I think.
Okay,
Whistles and fins.
Is there a motion on number 14?
I make the motion, we approve the order to, do I have to say that? Authorize the sale of fireworks for the San Jacinto Day fireworks period of April 16th, 2018 through midnight on April 21st, 2018, and authorize the county judge's signatory.
Okay.
I second motion.
There's a motion on agenda item number 14 from Commissioner Walker, second by Commissioner David Dobianski. All in favor, any discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Number 15, consider and take action regarding the burn ban and authorize the county judge as signatory. I would propose no action.
All right?
Agenda item number 16, receive any updates on the strategic plan. Commissioners, do you have anything to present today?
County attorney sent me an
a message a few days ago about, the weights officer could work under a constable, I think.
It was an AG opinion where another county, I don't recall which county, had asked the Attorney General whether there would be a prohibition on a constable or deputy constable working as a subordinate to the sheriff's office for weight enforcement purposes. Now, that would mean that the deputy constable was willing to do it. It brings up the issue, of course, of is he employed by the sheriff's office? Is there additional income? Various questions, but the question was being asked whether there was an outright prohibition because of the emoluments clause or the conflict of interest clause or conflict of interest issue, and I think the AG's opinion was there's no absolute prohibition on it. It'd be up to the county and certainly the elected officials involved, including the constable, as to whether that would be an arrangement that would work.
So in other words, you're saying that he could work under a constable?
Yes. Yes.
The constable could work for the sheriff's office for purposes of discharging the weight
constable could
enforcement.
work
That's
for
what,
the
yeah,
sheriff.
that's what that AG opinion was. Could it be the other way around? Maybe. I don't know if anybody's considered that. But apparently in one county, a deputy constable wanted to work for the sheriff's office enforcing weight regulations and they decided to ask the question whether it was prohibited by law, and the AG said no.
But is it prohibited for the weights officer to work under a constable?
You mean instead of being
Under the sheriff?
yeah, could that, I would assume, I don't know, that's a good question, I would assume. We'd probably want to talk to our constables and our, our sheriff's representative.
Yeah.
Whether there's any interest in this county at all, I haven't a clue. I was sharing the AG opinion, that's all I was doing.
And that's something that we want to look at for our next budget process, is trying to get a weights officer in there, because
Because we definitely need one in the county.
I got a call Saturday about, loads on 185. Said that the trucks were definitely overloaded, because they had the dump beds piled real high, one going down 185, tearing it up down there.
Is that a question?
No, yes, talk louder.
Oh, volume, okay, I didn't know what that meant. I thought you were one call.
What I was saying is that we want to look at definitely getting a weights officer in the next budget process if we can, because it's desperately needed in the county to stop some of this destruction of our roads in the county. Not only the county roads, but the highways too.
All right.
Thank you. Agenda item number 17, consider and take action to approve the interlocal agreement between Waller County and Grimes County regarding the 506th District Court and authorize the county judge as signatory. Attachment number 17.
Mr. County Attorney, has anything changed?
Commissioner, the percentage has changed. The percentage of last year's agreement, Grimes was responsible for 37.6482% of the salaries, benefits, travel, conferences, and related expenses for the court coordinator and the court coordinator, and Waller was responsible for 62.3518. This agreement proposes Grimes will pay 34.1619, which means our percentage went down about 3%, and Waller will pay 65.8381. To my knowledge, that's the only change, and as indicated, it's in our favor. I think it's based upon, the auditor could remind me, population, I think, and so I guess they revisited the numbers between last year and this year.
I move to approve the interlocal agreement between Waller County and Grimes County regarding the 506th District Court. Authorize the judge as signatory.
I second it.
There is a motion before us on agenda item number 17, first by Commissioner Mallett, second by Commissioner Walker. Is there any discussion, further discussion? All in favor say aye.
Aye.
All opposed? Motion carries. Number 18, Consider and take action to acquire real property for county purposes. It is expected that the court will convene a closed meeting pursuant to Texas Government Code Section 551.072, deliberation regarding real property.
Judge, my understanding was that the court intended to close the meeting for this agenda item.
Right. So we would ask all of our guests to depart, and if you want to hang around.